of Hilton versus the state. Counsel for the appellant.
Thank you, Mr. Chief Justice. If it pleases the court, members of the court, my name is Alex Morris. I represent Gary Michael Hilton. I believe the court is somewhat factually familiar, but briefly, Mr. Hilton was indicted for first-degree murder in 2008. The matter proceeded to trial in February of 2011. Mr. Hilton was convicted during the guilt phase, and at the conclusion of the penalty phase, the jury unanimously recommended that the court impose a sentence of death. Mr. Hilton took direct appeal to this court. His conviction was affirmed. He filed the post-conviction motion before the trial court. We proceeded to an evidentiary hearing, and the trial court denied the claims that Mr. Hilton presented, and this appeal follows. It's difficult for me to, I guess in a lot of circumstances, it's easier to address claims by going simply through the numbers in terms of as the claims are presented. However, many of the claims in Mr. Hilton's case overlap and they're intertwined with one another. I will start with the first claim. Mr. Hilton's position, our position is that the trial court erred in denying his claim of ineffective assistance of counsel. Mr. Hilton was denied effective assistance of counsel based on his counsel's performance or lack thereof during the penalty phase. More specifically, in the more general way of explaining it to the court, is that a life story of Mr. Hilton was never told. The most analogous case that I can draw this court's attention to is the Parker decision that this court rendered. I believe it was in 2009, if I'm not mistaken. The defense presented, I believe it was 4 expert witnesses, as well as 11 lay witnesses, if I'm not mistaken. But those witnesses did not serve or speak to Mr. Hilton's circumstances from a very young age, all the way to the point of when these circumstances happened. There was a general gloss of these were the circumstances that happened, but they weren't, the layers of the onion were not peeled back, if you will. I can draw the court's attention to the fact that the jury was never informed about the fact that Mr. Hilton's father actually had remarkably similar circumstances in terms of mental health and substance abuse issues. The argument then would have been very clear to the jury to demonstrate that Mr. Hilton suffered from defects that were not his responsibility, but were of origin of his family or his genes, if you will, his makeup. And going from there, at a very young age, Mr. Hilton, his mother was nurturing initially, but then rejected Mr. Hilton as she remarried. The gentleman that she remarried was a very dangerous person. This rose to a level that Mr. Hilton actually shot the gentleman at a very young age. Mr. Hilton was placed in what formerly used to be referred to as the HRS, and he was placed in housing with various different people. There are allegations of him having been sexually abused at a young age. Those are corroborated by other individuals. Roy Cave would have been the witness that would have been able to have testified to that. We then get to Mr. Hilton's teen years, where he's 17 years of age. He is entering into the military. He has a relatively short military career because he begins to start manifesting major mental health issues. There are multiple different relationships that Mr. Hilton had, and with varying degrees of success or failure, but he did establish relationships, by way of example, with the daughter of one of those spouses or girlfriends that was an excellent relationship and a positive relationship. There was a lengthy drug history starting at a very young age, multiple different substance abuse issues related to drugs as well as alcohol. Then we get to the point in time chronologically prior to the homicide, or I'll say homicides plural, in terms of Mr. Hilton's instability in Atlanta, Georgia, and the surrounding areas, and him manifesting erratic behavior. And witnesses were available and able to be called in that regard. Mr. Hilton was wrongfully and inappropriately prescribed 2 different drugs, Ritalin and Effexor, and at a contemporaneous with the wrongful prescription of the medications is when we see Mr. Hilton having a breaking point or a detachment from what one might consider normal behaviors. And this is when,
Morris,
yes, sir.
Morris, if I can interrupt you for a second. Going back to the available evidence or available history of Mr. Hilton's growing up. Apparently, the argument that's been made here is that the defense, in this case, they were not working well together, and there was a lot of disarray in the presentation, and apparently the attorney who was in charge of the penalty phase, I believe by the name of Friedman, took the position that he's not very good with lay people as far as presenting them. He was better with experts. So the strategy here was basically just to call experts and not so many lay people. In doing so, however, this lady by the name of Betty Fuentes, who was a mitigation expert, apparently she had put together a very well-developed case for Mr. Hilton's early years as far as abuse, and I think he shot his stepfather, and I mean it was just a horrendous early childhood. So I guess the question I have for you is, we know the law that counsel's attorneys are entitled to make their own come up with their own strategy as to how to present testimony. However, that strategy has to be a reasonable strategy. And do you feel that the strategy to pursue just experts in this case, make it an expert intensive, as opposed to presenting lay witnesses as to this person's background, was that a reasonable strategy? I guess that's my question.
Well, I can answer it in the court's question in 2 ways, Justice. First and foremost, no, I do not think that it was a reasonable strategy. But I think that this court's case law, as well as the United States Supreme Court's case law, is also clear that it's not necessarily my role to criticize strategies, and it's not necessarily the court's role. But the question becomes is whether there was a strategy or not. And in this circumstance, I don't think that there was. And you hit on a very important issue, that there was great disarray and dysfunction among trial counsel. Ms. Fuentes had done an enormous amount of work in preparing mitigation witnesses, cultivating evidence that could be presented to the jury so a life story could be told to the jury. Mr. Friedman, because of the dysfunction of the defense team, Mr. Friedman, who had not handled a penalty phase previously, made the decision, and the record supports this decision from other witnesses, that Mr. Friedman wasn't very good with lay witnesses, and so he decided to streamline everything and simply attempt to present things through the experts. No, I do not think that that was a sound strategy, because it neglected to tell the actual life story of Mr. Hilton and put some tangential value and humanity that was associated with the facts that the experts had theoretically considered. And in this circumstance, it's clear that the experts didn't have the benefit of considering all of that information or that evidence.
Well, if I understand, going back to the disarray that was going on, apparently the elected public defender in this case, assigned, it got so bad that she assigned the case 90 days before trial, and assigned Mr. Friedman to do the penalty phase, and he who was not qualified, as far, I'll say qualifications from the sense that he never done one before, as he is required to have done, and also assigned the guilt phase to Ms. Suber. And those two apparently were not working. One was working on guilt, one was working on penalty, and they were not connecting with each other. So going from that as a starter, and then they do not present to the jury this person's background, which was extensive as far as abuse and that type of thing. I'm just wondering, whether or not there could be any possible reasonable strategy for not pursuing lay witnesses to come in and testify about his abuse and all those things in early childhood in exchange for expert testimony.
I think disconcertingly, there wasn't a strategy, as the evidence from the evidentiary hearing demonstrates to the court that these people couldn't even talk with each other. The defense team was so dysfunctional. The guilt phase lawyer, Ms. Suber, was not communicating with the penalty phase lawyer, Mr. Friedman. Neither one of them had any idea what the other was going to present. There was no commonality of theme. Mr. Friedman came into it at the 11th hour. It's one thing to try a grand theft motor vehicle case and receive it 90 days prior to trial. It's an altogether different thing to receive a death penalty case of this complexity, of this magnitude, 90 days prior to trial, and be able to be adequately prepared for the penalty phase and the presentation of witnesses. And the evidence that was presented at the evidentiary hearing was that counsel in the penalty phase actually discarded or irritated witnesses or inflamed the senses of witnesses and simply unilaterally made determinations of not calling witnesses. And by way of example, if we look at Dr. Delcher, who was presented during the evidentiary hearing, Dr. Delcher is the gentleman who wrongfully prescribed Mr. Hilton Effexor as well as Ritalin. Dr. Delcher was suspended from the practice of medicine in Georgia. The jury learned brief tidbits of that information, but in some way, shape, or form, penalty phase counsel decided not to call Dr. Delcher because they now characterize it as being strategic, that he could potentially say something bad or poor against Mr. Hilton. But if the court takes a look at the testimony of Dr. Delcher, Dr. Delcher's testimony was actually very informative in terms of describing not only his role in observations in Mr. Hilton's demise and how rapidly that occurred, but it provided substantive and tangential information for the jury's consideration of a medical doctor potentially being complicit in Mr. Hilton's demise. So I've got to agree with you, Justice LaVarga, in the sense that there was absolute chaos among the defense team.
Counsel, let me ask you this. What other witnesses were presented at the evidentiary hearing that are relevant to this issue that you're raising about the failure to explain the life story of Mr. Hilton?
Well, first, Dr. Norman Camp, who was he's a military psychiatrist, presented evidence in terms of the chronology and explanation of how Mr. Hilton was separated from the military. Secondarily, Dr. Delcher was available. And then through stipulation of the parties, evidence was entered in terms of declarations and statements that provided the chronology. Ms. Fuentes testified at the evidentiary hearing with respect to the some 300 individuals that were interviewed. And I don't suggest to the court, Chief Justice, that there should be an expectation that all 300 witnesses were going to be called.
Well, wait, let me ask you this. Which of the lay witnesses that you believe that counsel was derelict in not presenting their testimony at trial were presented at the evidentiary hearing?
Well, let me give you a couple of examples. The first example that I can provide for the court is Roy Cave actually testified and took the witness stand in the penalty phase in Mr. Hilton's trial.
Well, now, wait a second. That's not my question.
Okay.
I understand you may want to. If I understood part of your, at least a significant part of your argument, is that the counsel failed to put on lay witnesses that should have been put on if they'd been doing the job that they should do to explain Mr. Hilton's life story. And now I'm asking you, which of those witnesses were presented at the evidentiary hearing?
Beyond Dr. Delcher and Dr. Camp, the answer to the court in terms of lay witness testimony is there is not testimony from them. However, there are declarations in evidence from them.
Thank you.
Yes, sir. From there,
Counsel, I'm sorry. We have helped you move into your rebuttal time. You just need to be aware that you're now have only a little over 3.5 minutes of your rebuttal time left.
fair enough. I'll wrap up with this. The defects in the defense, their lack of preparation, the discord, disharmony left Mr. Hilton in a circumstance where he did not receive adequate representation and effective representation in the penalty phase. And as a result, it is our position that the trial court erred in denying his claims, and this court should reverse for a new penalty phase. And then I'll reserve the remainder of the time, Your Honor.
Thank you. Counsel for the state.
Morning, may it please the court, Michael Kennett for the state of Florida. This is the appeal of the denial of the initial motion for post-conviction relief in Mr. Hilton's case. I'll start by saying that the evidence of guilt in this case was overwhelming, and the evidence of aggravation in this case was overwhelming. What does that mean? That means it's almost impossible for the appellant or petitioner, depending upon whether it's the allegation of ineffective assistance of trial counsel or appellate counsel, would have a very hard time establishing prejudice under Strickland. That also means that when evaluating the performance of appellate counsel, it'd be very hard to show that an unpreserved claim was fundamental. It also would make it easier for the state to argue on appeal had an issue been raised that it was harmless. So again, the evidence of aggravation, overwhelming, the evidence of guilt, overwhelming, and that makes a big difference in the analysis of the post-conviction claims here. To touch on what Chief Justice Kennedy mentioned and what the trial court explicitly said in its ruling, none of the evidence presented at the evidentiary hearing would have made a difference at trial. None of it. And that's a correct ruling, and the appellant does nothing to sufficiently challenge that ruling on appeal. With regard to the IAC claim for the penalty phase, the appellant argues that the lead counsel for the penalty phase, Mr. Friedman, didn't do enough to tell the life story of Mr. Hilton. The trial court found otherwise. The trial court found that whatever additional evidence was presented at the evidentiary hearing was cumulative largely to what was shown at trial. And Mr. Friedman, he testified that he was well aware of the fact that the state would try to portray Mr. Hilton as a psychopath. And so he had a strategy of trying to minimize the opportunities or minimize the risks for the state to be able to do that. And that is why he chose to use expert witnesses, because he didn't want to open the door to other behaviors during Mr. Hilton's life that could support an antisocial personality disorder. Even his service in the military could be consistent with that. If you look at it, the defense wanted to argue, or post-conviction wants to argue, that shows that Mr. Hilton had some kind of severe mental disease or defect, but it could also be consistent with antisocial personality disorder. And that is really the fight in a lot of capital cases, especially in the penalty phase. The defense wants to argue mental health mitigators, a severe mental disease or defect, and the state says, no, this guy is just a psychopath. And so someone in the military, maybe it was exciting at first, and then it's not so exciting anymore. And what Dr. Camp actually testified to is that Mr. Hilton took the easy way out. He took a convenient way out and said, yeah, okay, I've got a personality disorder. I want to leave now. It's not fun for me anymore. The drug use could have been consistent with antisocial personality disorder. He has drug use throughout his whole life. So again, nothing testified to at the evidentiary hearing would have made a difference. And as far as Dr. Delcher goes, Mr. Fuentes, or Ms. Fuentes and Mr. Friedman both understood before trial that Dr. Delcher thought that Mr. Hilton was dangerous. So yes, there could have been some positives that came out for the defense by calling Dr. Camp or Dr. Delcher the overprescription of Ritalin, but at the same time, to have a defense witness say, right before these murders took place, I was afraid of this guy. And even at the evidentiary hearing for post-conviction, Dr. Delcher said he wouldn't trust anything Appellant said now.
Mr. Kennett, can we hear from you your assessment of the state's compliance with the applicable rules of procedure with respect to providing a list of designated witnesses, documents for the Georgia case, and whether the timeliness or untimeliness of its compliance with those resulted in a substantial disadvantage to the defense in this case?
My first response is to say that would be more of a direct appeal issue, not a post-conviction issue. But I understand your question. And as it relates to the IAC claim, perhaps, for the guilt phase. And the trial court, in this case, said in the post-conviction order that it wouldn't have made a difference. That Ms. Suber acted professionally. She objected when the state attempted to call the witness. The trial court gave the defense the opportunity to interview the witness and depose the witness. Ms. Suber interviewed the witness. But even if she had been aware of the testimony beforehand, she couldn't have done anything to change it. It was an admission by her party opponent, an admission by Mr. Hilton when he was in jail awaiting trial that was to a fellow inmate but overheard by a correctional officer. So additional time wouldn't have changed anything, and the evidence of guilt was overwhelming in the case. The appellant tries to argue that that somehow that changed the theme for the defense during the guilt phase, and that's just not true. First off, the defense's hands were tied because Mr. Hilton said unequivocally, if they're not going to give me a life sentence, I want to fight everything. I want to make them pay for everything. And so that's what defense counsel did. It wasn't an innocence defense, and it wasn't a circumstantial evidence defense. It was a reasonable doubt defense or an adversarial testing of the state's case. And if you look at the opening statement of Ms. Suber at trial, she said, there is direct evidence in this case, and she said there's also circumstantial evidence in this case. And the theme during her opening statement was pay attention, pay attention. It was a reasonable doubt theme. So it isn't like if the state had disclosed the witness prior that the defense strategy would have been different. And the appellant fails to show or articulate what a better strategy would have been, particularly when the defendant himself wanted to fight everything. So yes, that is an important issue in the case, but again, it didn't matter. None of the evidence presented at the evidentiary hearing would have made a difference at trial.
Let me ask you a question on that, because I've heard you argue that a number of times, and you do have some weighty aggravators. You got HAC, you got CCP, you got a prior violent felony, you got in the course of the kidnapping, and you got to avoid arrest. Those are weighty aggravators. But you know, before we had the unanimity requirement for death penalty in juries, I used to see cases just as strong coming back with 8-4 jury recommendations, 10-2, with the same aggravators in there. And the case having been just as heinous and as atrocious as this one, as to what happened to the poor victim. But you've seen those. you ask yourself, how can a jury come back with anything less than a 12-0 on this? Yet you see 8-4, 10-2, and less than that. So there's no such thing as a locked case, anything involving what caused a person to behave in a certain way because of what happened to them early or whatever like that, that can have an impact on a juror's vote on the death penalty. Now, as far as guilt is concerned, that's a different matter. Don't you agree?
Yes and no, because as it's always a double-edged sword. And that's why I said earlier that there's always this debate during the penalty phase. Is it that the defendant has a severe mental disease or defect, or is he just a psychopath? And that was the debate in this case. The defense wanted to show that he had schizoaffective disorder with perhaps bipolar, but the state said, no, he's antisocial personality disorder. He's a psychopath. And let's look at the aggravation. The CCP, he hunted people. He targeted people based upon their locations. He chose national forest hiking trails. And you look at the facts of this case and the facts of the Georgia case, they're strikingly similar. He targeted women who were by themselves on hiking trails. That's CCP. Let's talk about HAC. He kept them alive for days, both in the Florida case, this case, and in the Georgia case. He kept his victim alive for at least 4 days. And in this case, the victim was well aware of the fact that her life was in danger, and she kept trying over and over again to get Mr. Hilton to convert to Christianity. That was her one attempt, I guess, her best attempt at saving her own life. But she was kept alive for at least 4 days in the woods. He kept her alive so that he could use her ATM card to pull as much money out of her account as possible. So we have clear HAC, clear CCP, and we have a prior violent felony conviction. Within the span of 30 days, he did the exact same thing, once in Florida and once in Georgia. That's exceedingly aggravating. He hunted women. He cut their heads off and then had sex with their bodies. That's incredibly aggravating. He kidnapped them. I understand your comment, Justice Clark, about 8 versus 4, 10-2, 12-0, but again, I go back to what the trial court said. Nothing that was presented at the evidentiary hearing would have made a difference in this case. Because he hunted people for fun and he killed them. It's perfectly reasonable for a jury to say 12-0. It's not a surprise. I understand your question about other cases, but we never know the makeup of juries. We never know their motivations. So we have to look at the evidence from a rational perspective and in examining the prejudice component for Strickland. And if you do that in this case, clearly nothing presented at the evidentiary hearing would have made a difference. Absent any questions, the state would ask this court affirm the denial of appellant's post-conviction motion as well as deny the petition for writ of habeas corpus.
Thank you, counsel. Rebuttal.
Thank you, Mr. Chief Justice. Just back to Justice Coriel's question, in terms of the late disclosure issue, I don't think that the timeliness of the disclosure actually is the main issue. I think that the main issue is that defense counsel, contrary to what the state argues in terms of there being direct evidence and circumstantial, during the guilt phase, the trial lawyer presented matters as if it was a circumstantial evidence case, unaware of the fact that Mr. Hilton had made a statement against interest that was overheard by a guard at the Leon County Jail. That came almost at the tail end of the guilt phase. So all the while, there's argument of it just being a circumstantial evidence case and not a direct evidence case until the bombshell drops. Well, the point really behind that is the dysfunction of the preparation. The record from the evidentiary hearing is replete with what the disorganization of the actual documents was, who was in charge of particular witnesses, and to miss or not be aware of the fact that a witness is going to testify that Mr. Hilton made statements against interest is a difficult one to overcome, no doubt. Also, to Justice LaVarga's question on the 8-4-10-2, I think it's a little disingenuous for the state to argue, oh, it's a 12-0 vote, and nothing would have helped. Well, that's not true, because that information was not presented to the jury for their consideration. And had it been presented for the jury's consideration, we may well have an altogether different recommendation from the jury. And so in the absence of that information being presented, that is absolutely why there's a 12-0 recommendation. With all of those things said, I would again request that Mr. Hilton's case be reversed and remanded for a new penalty phase. I would stand on the arguments as presented in the petition for writ of habeas corpus as they're presented in that brief. I appreciate each of your time.
Well, thank you, counsel. We thank both of you for your arguments in this case today. That's the last case on today's docket. So the court will now stand in recess until tomorrow's session of court. Thank you.